will be your host this morning. So without too much ado, we're going to offer some housekeeping rules. We do understand how precious Saturday mornings are and that there may be things that pull away at your attention during our time together, but we encourage you to participate, to raise your hand if you have questions, or you can post your questions right directly in the chat. We have somebody monitoring the chat box. But we encourage you to engage and invite you to do so. We also encourage you to stay on mute unless you have a question, just to minimize the distractions for our speakers today. And just to make you aware, we are recording today's presentation, and we can make that available after the session to anyone that is interested. And lastly, we will have a survey that we will launch right at about 5 minutes to 11. And so we do hope that you will take just a moment to respond to the survey. That helps us to know for future programming if this information was beneficial and how we can assist in the future. So again, thank you, and we will go ahead and get started. I will introduce our first speaker. So Nadia Douglas grew up in Central Florida after relocating from the Bronx, New York, with her family. As a Florida Bright Future Medallion Scholar, she attended the University of Central Florida, where she received her Bachelor of Arts in Political Science, as well as a minor in Legal Studies. Nadia received her law degree at Barry University School of Law, where she held several leadership roles, including Student Bar Association Senator and Executive Board Member of Immigration Legal Society and the Christian Legal Society. She attained book awards in motions and depositions, trial advocacy, and law office practice. While pursuing her studies, Nadia worked for her family law and business litigations firms, where she drafted pleadings, motions, and discovery before joining a large defense firm in Maitland, Florida. During this time, she represented some of the largest insurance carriers within the state, gaining extensive experience defending property damage claims, including mold remediation, water mitigation, fraud, sinkhole, hurricane, and plumbing claims. Nadia is admitted to practice in all state and federal courts throughout Florida, and her primary practice area is first party property representing residential and commercial property owners, defending their claims against insurance carriers. What I'm basically trying to tell you is that Nadia is qualified. So whenever Nadia is not acting as an attorney, she is actively involved within the community and her sorority, Alpha Kappa Alpha Sorority Incorporated. She's a member of Delta Omicron Omega, and we thank her so much. She also enjoys museums, traveling, and spending time with her family. So after that long and uh, beautiful introduction, again, we just want you to know we're not just bringing anybody before you, we are bringing those that are qualified. And we do have another speaker. We're going to introduce her when her charts come up. And we want to thank Jeanette as well for joining us this morning. Even in the midst of all she has going on personally, she's still with us this morning. So I won't talk anymore. Nadia, I'm going to turn it over to you at this time.
Thank you, Irma. And thank you all for being here. Good morning again. Like Irma said, usually our home is our biggest asset. It's our biggest investment. So this presentation, along with Jeanette's presentation, is going to hopefully assist you with protecting your legacy. And the first step to protecting your legacy, when you buy a home, you get two things: the keys to the home, and then you get your deed. So I'm going to present how to protect the property from an insurance attorney standpoint, right? So I believe the slide is going to be, the PowerPoint presentation is going to be shown to you all here in a second. And so while that's coming up, whether you are a homeowner, whether you are searching for a home, and whether you are planning to purchase a home in the future, this is going to be particularly important. And so if you are a homeowner, you do have your policy. Feel free to pull out your policy, your deck pages, and try to pinpoint where the information is in your policy. And if not, do that later. So, like Irma said, I'm Nadia. I have been practicing in Central Florida, and I represent homeowners and commercial property owners. Next slide. The way to protect your property, one of the best ways to protect your property is through your homeowner's insurance policy. So what a homeowner's insurance policy is a contract between your carrier and yourself. It protects your property from certain types of perils or losses, right? A peril is defined under the policy. It's a certain type of loss. So a hurricane, fire, theft, plumbing leaks, wind storms, hailstorms, things like that. The policy is going to tell you what conditions or perils under the policy that is going to be paid, and it'll stipulate what exactly is covered and to what extent, right? So the policy is not for any kinds of loss, it's for direct physical loss or damage to the property. It also pays for living expenses that arise due to the loss. So let's say, a hurricane damaged your house, you can't live in it, you have to go and stay in a hotel or you have to rent a property. Those types of expenses are covered or under policies to an extent. Cosmetic damages are also covered. So here you see the fire damage. This looks like the kitchen. That cabinet is destroyed. Cosmetically, right? It may be functioning. You may be able to open it up, but it's full of smoke. It is not going to function. I'm sorry, it may still function, but it's not appearance wise as it was prior to a fire. So cosmetic damages to the floor, to the cabinets, painting, accessing pipes, all of those are covered depending on your policy. It also covers structural damage, so damage to the roof when the roof is compromised, but there has to be actual physical damage in order to trigger all of the other coverages under the policy. Next slide. So now I'm going to talk about just some of the basics for homeowners insurance policies. There are two very important types of policies: an actual cash value, that is the property as it is worth today. So today, as many of you know, the houses are worth a lot more than they were maybe 10 years ago, right? So today's value, if your property were to be damaged today, they would value it at today's price if you have an actual cash value property. Actual cash value policy, as opposed to a replacement cost. That is only the amount necessary to restore your property at today's costs. The deductible, that's the amount of money you pay out of pocket on any covered loss. And then there's limitations on your payments, the payments you'll get under the policy. The four important coverages under any policy are coverage A, which covers your dwelling; coverage B, other structures. So that would include your fence. It would include a dock if you have a dock at your property, a shed if you have a shed on your property; personal property under coverage C. So that's going to be your clothing, your furniture, your appliances, your TV, things like that. But I want you to pay special attention to coverage C, and it'll become more apparent why on the next slide. Coverage D is what I was referring to earlier under loss of use. So if you are displaced, you have to rent a property, or you have to be in a hotel while the property is being fixed, or while the insurance company is investigating, then there's a limit on how much the insurance company will pay, right? So you can't just go to the Ritz-Carlton and have a $500 a night. There may be a limit, right? You may have like a $5,000 limit, and that $5,000 is going to be eaten up pretty quick if you are at Ritz-Carlton. So the policy limits are placed on the covered property, and they depend on the amount of coverage to the home itself. Replacement cost value is more desirable, and it usually does not add much to the cost. Next slide.
Nadia, I have two questions. So,
Okay.
and I'm sorry, if we could go back to the previous slide. The first question regarding the types of policies, and you mentioned it, with the increase in home values. Many of us got our insurance policies years ago when we first purchased our homes. If we were to have, some kind of catastrophic event that, where we'd have to basically replace our homes, would that be at what it's valued at today, even though I got my policy 11 years ago? Or, would it be at what the home was valued back then?
So that's a great question. And I hate to give you this lawyer answer, but it depends. It depends on what was damaged, how much it costs to fix at today's price, right? So if your roof is damaged, depending on how big your roof is, and it was damaged today, and let's say your policy is a $100,000 policy, your roof, I mean, unless you have a huge, maybe 100 square feet concrete tile roof, $100,000 will probably suffice for that roof. Now, like I said, it depends on the size, it depends on what type of damage, and it depends on how much your policy value is. So you want to look at coverage A, right? That's your dwelling. So if it's roof damage, you look at coverage A and you say, okay, right now my house is X amount square feet, a concrete tile roof, that's going to cost you anywhere maybe $1,000 to $1,500 per square, right? And so that can add up. The average roof, if you have shingle roof, then that's about, we estimate about 350 to 550 per square in today's prices, right? 5 years ago, those prices were 250 to 350 per square. So that adds up. Now, if the value of your policy or your limit has not gone up, then you just want to review that. And if you don't want to review 75 pages worth of policy, any decent attorney can help you review that. Your realtors can help you review that. Your insurance agent should be able to help you review that. But I would say, definitely give me a call. I don't charge homeowners or commercial property owners to consult or review their case or their policy, because you want to make sure you have enough coverage, especially when you don't have, $20,000 in the bank to replace your roof, right? If you don't have that money in the bank, and we have hurricane season every single year. So if a hurricane comes and your roof is damaged and it's no longer functioning, it's no longer protecting your property, you want to know, okay, how much is it going to cost? This is the square footage of my home. This is how much a roof would cost me today. Do I have enough coverage under coverage A? So that's why it's really important. And that's why I hate that answer. It depends, but it does depend.
Thank you so much. And then the second question I received are, and I see another question in the chat too, but the second question I received regarding the limitations on payments, are these four limitations, are those a standard part of every homeowner's insurance?
Yes. Every homeowner's insurance policy will have coverages for the dwelling, other structures, personal property, and loss of use. The only thing that's going to change is how much coverage. And you can negotiate what those coverages are. Like, I don't need $1 million of personal property, so why don't we just do more for my dwelling? Or, I do have a boat dock, I do have a boat, let's get my boats covered. I would like to stay at Ritz-Carlton, so let's increase my loss of use coverage, right? So those things, the amounts will differ, but those coverages are pretty standard on every insurance policy. And then I saw in the chat, is there a certain type of attorney we should consult with to review the policy? Any attorney, all attorneys get trained in essentially all of the core areas of the law. So any attorney is able to review it, but I would seek the counsel and advice of a property insurance attorney like myself, who has experience and who can say, yes, you have enough coverage, or look at this particular coverage, and this will become apparent in the next slide. All right, so here's an example of a declarations page. And like I was saying before, usually a policy is, anywhere from 70 to 100, maybe 125 pages. There's 4 pages called the declarations page, and it shows just this small snippet of what your coverages are. Here, this particular property, and this is an actual client of mine, his dwelling A coverage was $833,000. You see his other structures were only 16,000. So you see how much that differentiated. Obviously, he has a huge home. He did have a boat dock, and when that was damaged, he was very upset that it was about $60,000 worth of damage, but that dock was only covered up to 16,000, right? Because it was the dock, it wasn't the actual house. So you have to think about these things when you are selecting your homeowner's insurance policy or negotiating for your rates. Personal property, he had 208,000, and then loss of use 83,000. So another example as to why you should always review your policy. If you go to the next slide, you'll see this is the ring on the screen that you're showing. It's a Blue Nile ring. I got it off the internet. It's a $60,000 ring, right? Now, you would think you have personal property is covered under your policy, right? He had 208,000 personal property coverage. There's a section called special limits of liability, right? These are the internal limits that also apply to specific items. For example, money, securities, watercrafts, jewelry, firearms, silverware. If you can see here, this small print, this was on page 39 of 74 of his policy. This small print shows he is only insured for jewelry up to $1,500. So that Blue Nile $50,000 ring, yeah, that we're gonna give you $1,500 for that. And so this is why it's very important. And I know that this is not sexy material, right? It's a lot of small words, fine printed in 100 pages. But this is why you have to look at your entire policy. And if you don't want to, call me. I'll do it for you, and I'll point out, I'll red line and highlight the special places, special limits of liability to show you this is what you're paying for every year, but this is what you get. I had a burglary client, and their passports were stolen, birth certificates, social security cards, jewelry, all of the important things that were in the safe. And her insurance company literally only gave her, for her documents, I believe, a total of 2,000, and that was the limit. There's nothing that I, a judge, or a jury can do, because if you sign a policy that says I'm okay with paying X amount of dollars per year, and in page 39 it says I'm okay with covering my jewelry for only $1,000 and my passports and important documents for $2,000, there's nothing I can do to get you more money. I can get you the 2,000, but I can't get you any more than that because of the policy. The policy is a contract, it's binding and enforceable. All right, next slide. So second thing that you can do after you review your policy is inventory your property. This is going to help you protect your property. You can take a written inventory, so you can include the make, model, serial numbers of items. These are like the big items, like appliances, your stove, your fridge, your microwave, dishwasher, your TVs, all of the TVs, right? You can do that written. You can do a digital inventory. There's different home inventory apps, so that you can take a photograph, and then you can put the description of the item, the value, the date that you purchased it, all that good stuff in there. Or you can take a visual record, right? If you're like me, you don't want to put all the tedious stuff in an app or write it down. You can take pictures of everything. Take a picture of the serial number, just make sure it's a clear picture. This will be very important if there was a fire, there was a hurricane, you were displaced, because it's going to be emotionally tolling going through just the loss of your biggest asset, right? The loss of use of your biggest asset. Who wants to sit down and think, I had 3 TVs, I have about a $20,000 shoe collection. That's very important to me. I have those written down. I have the receipts and very nicely. My TVs, I have a picture. I just have the picture of the serial numbers, right? Because these are things, what is important to you? If something were to happen, this is very important. My shoes need to be replaced. I can't get around without my shoes. So it's very important to inventory your property. It's critical to post-storm recovery in the event your home or belongings are damaged. And like I said, trying to remember everything is going to be very, very difficult, especially when you're dealing with recovery and the investigation process of a claim.
Nadia, you have several questions in the chat. So the first question, for personal property, do you recommend to get an individual insurance for personal property that would exceed your home insurance?
So I'm sorry, but it depends, right? It depends on what is important to you, right? So my client had $208,000 policy for his personal property. Now that was enough for all of the appliances, the televisions, the furniture, but not for jewelry, things like that. So yes, if you have a $50,000 ring, or even if you have a $5,000 ring, whatever is important to you and you want to make sure it's insured, if you cannot get the limit increased in the policy at an affordable rate, then exploring other options for personal property insurance at reasonable rates, it is something that you want to do. So it depends on what is important to you, what the value of all of your belongings are, and how much is it going to cost you to pay for that insurance. I am a big proponent of insurance. We get health insurance, we get our life insurance, and homeowners insurance is equally important because it is at most times our biggest asset. So great question. I see that.
Two more
Are there
questions.
any homeowners insurance policies that cover 100% of the property? So each homeowner's insurance policy is supposed to look at the value of your home when insuring and insure that value, right? So it depends on how they value your property, depends on the square footage of your property. Now, 100% of the dwelling is what they are supposed to cover because they're taking the value of the property. So let's say you have a property that is, if it would cost $100,000 to replace this property, they should have coverage for $100,000 because that's how they determine the coverage in the first place. What is the value of your home? The next question: do you have a digital inventory app that you would recommend? One that is user friendly. I can send out, if you want to put your email in the chat, I will definitely send you a couple of the digital apps that I have personally seen, and which one, the order of recommendation that I prefer. I think that's the last. Okay, would obtaining personal property insurance be beneficial as a renter? So I don't particularly handle renters insurance, but yes, when I did rent, I did have renters insurance because, like I said, I have a huge shoe collection, and those shoes are very, very important to me. So it depends on what is important to you, what are the value of your belongings, and shop around for rates. All right, so let's go to the next slide. And I do think everyone, rent, own, planning to own, searching for a home, definitely taking an inventory is going to be helpful in the event that you have damage. So insurance claims, after you've purchased your home, hopefully it does not get damaged, but in the event that it does get damaged, you have your inventory. The next thing is to file an insurance claim. So the process for filing an insurance claim is the first step, reporting the insurance claim and the damage to your insurance carrier. The insurance carrier will then investigate, and then they will come up with a determination. There's 3 ways to report the insurance claim. You can do it yourself. You can hire what's called a public adjuster. A public adjuster is not an attorney, but they can negotiate on your behalf. They do have a wealth of knowledge regarding the damage process. However, they do take a percentage of the funds that you would have received from your insurance company. So let's say you have $20,000 worth of damage. A public adjuster will usually take between 10 to 20% of that money. And so that's a personal decision that you would have to make. Or you can hire an attorney. Now, there are different attorneys, there are different law firms that handle first party property claims. My firm, we do not charge anything to the owners, right? If the owners need 20,000 and I'm as an attorney wanting to take 30% of that, how is the homeowner going to fix their property? So at my firm, we firmly believe that we cannot take the homeowner's money, and we shouldn't, because Florida is one of the great states that allow attorneys to get paid directly from the insurance company. So if you need 20,000, you call my firm, you're getting your 20,000 and I'm getting my fees from the insurance company, separate from the funds you need to fix your house. But every firm is different. So those are the three ways you can report. And there's some common misconceptions. Should I report my insurance claim? Should I report damage? My insurance will go up. I don't want to do it. Like when I got in a car accident, my insurance went up. So I don't want to report anything on my house. That's a common misconception, right? Your insurance will go up regardless of you reporting a claim or not. And if your house, let's say your roof is 20 years old, that's an expensive insurance policy you're going to have because your roof is older. It's more susceptible to damage, right? So the newer your roof is, the less your homeowner's insurance is going to be. If you do report a claim, they can't raise your premium because you reported a claim. They can raise your premium because you didn't fix your roof. If they deny your claim and you don't fix it, now your premium can be raised, right? They can't drop you because you report a claim. They can't non-renew you because your investigation of your claim is still going. So those are just some of the misconceptions I wanted to point out. And then when you're reporting, one of the very first things you're going to be asked is, what is the date of loss, right? So sometimes homeowners don't know the date of loss, or they'll make a date of loss up. If you don't know, you truly don't know, stick to that. I do not know. This is the date I recognize the damage. And that's why it's important to have representation or to consult with an attorney so that you know these things. And it's important to know what the date of loss is, or to let them know you do not know, because they're going to use that date of loss to determine what the value is, how much they owe, right? Actual cost, actual cash versus replacement cost. They're going to want to know what date, because if you have a date of loss from, let's say, 2017 when Hurricane Irma hit, guess what? You reported it too late in 2022, so you can't recover for that. So date of loss is very, very important. Next slide. All right, so the insurance investigation, if you are going to do this yourself, or whether you're going to do it yourself, hire a public adjuster or hire an attorney, you're going to want to prepare for the insurance company's inspection. They're going to come out, a field adjuster is going to come out on behalf of your insurance company. You want to write down some questions that you have about the claims process so that you can ask of that field adjuster. You want to give the adjuster the pictures of your inventory, right? The belongings that you have in your house. Ask for any resources, but definitely get the contact information for that field adjuster. Now, if you have an attorney, you don't have to ask anything of the field adjuster. The attorney should handle all of that. If you hire my firm, we absolutely will handle all of that. And they are not allowed to talk to you once you have an attorney. The attorney is the point of contact. After they do an investigation, after they do the inspection, then they'll start the investigation process, which will be determining how much you need to restore your property to its pre-loss condition, right? How much do we owe to fix Nadia's property to be as it was before Hurricane Irma? They're going to think, okay, are there any upgrades that need to be done? That's also a limit under the policy. It's usually a percentage of coverage A. They're going to determine whether they need to pay the actual cash value or the replacement cost. Then they're going to want to determine, how long is she going to be out of the home? Do we need to pay for temporary living expenses? So the insurance company will also probably hire an engineer. An engineer is the only person that can say, yes, this windstorm damaged this roof, or no, it did not. And if they send out an engineer, you definitely want to have an attorney at that point, because who is there on your behalf, right? They've sent out a field adjuster, they've sent out an engineer. You are speaking directly with the insurance company. no one is there representing your best interest. Unless you're very savvy in the insurance field, you're going to want to have somebody there for you. Then they'll make the determination. They're either going to provide coverage, full coverage, the full 20,000 if that's what you need, or they're going to underpay, which is most usually the case. They'll pay 50% of that, or they'll say, oh, it's only $5,000 to fix your roof, not 20. Or they'll flat out deny you. Those are the three determinations. Next slide. So once you have your determination, whether you're denied or you're underpaid, there's different things that we can do in order to remedy as far as getting more funds to fix the property. The things that we can do that are before litigation are request mediation in front of an impartial mediator, appraisal. That's where the insurance company has their inspector, and then the homeowner will hire an inspector. Both will go out, inspect the damages. If they don't agree, an umpire will say what the damages are. Before filing a lawsuit, an attorney can file a demand letter. They can file a civil remedy notice with the state. That is just an allegation that they have not investigated properly, they have underpaid or lowballed, and you would like them to remedy the situation within 60 days. Finally, if those do not work, we can file a lawsuit. And again, we file lawsuits on behalf of clients at no fee to the clients. And you have to really think about filing a lawsuit. Now there are certain requirements for lawsuits in property. Before you can file a lawsuit, you have to give the insurance company a 10-day notice of intention to litigate. So if you're doing this yourself, you definitely want to at least consult with an attorney to know what the requirements are. Next slide. All right, so as we wrap up, just remember, protecting your property, 3 things to be sure to do. Check your policy, the entire policy, not just the declarations pages. And if you really want to use the shortcuts, just hit Control F, pull up a PDF copy of your policy, hit Control F, search for the word jewelry, search for the word securities, search for the word documents, search for these words that you want to make sure you have enough coverage so you can see, okay, my rings, my earrings, all of my jewelry is covered under up to this much. Fur coats, there's also a limit on your fur coats. So definitely check your policy. Number 2, make an inventory of everything, all of your belongings that you want protected in the event of damage. And then step 3, remedy your damages. Once you buy a house, you're going to have an inspection, right? If there are damages at that inspection that are not fixed and they are noted in the inspection, the insurance company may deny you for not remedying those damages. So you want to remedy those damages. And the best time to do that is before you finish your purchase, right? Tell the sellers, hey, the roof has some repairs that need to be made. Those need to be made before we close. And your realtor can negotiate that on your behalf. Now, if you're denied, let's say you're denied for your roof and you don't fix the roof. The next severe windstorm, rainstorm, hailstorm, then your roof is more damaged than it was the first time. Your insurance company is not going to pay for it because you already have pre-existing damages. And that's something that I see a lot of as well. So definitely remedy any damages that you are aware of. So if there are any questions, I will take them now. And you can go to the next and final slide. Is there a separate insurance? Say again, I'm sorry.
Oh, no, go ahead. Sorry.
Yes. Is there a separate insurance for firearms, or would it be under personal property? Look, it's under the special limits of liability. It's not under personal property. So when you do your Control F, you want to search for the word firearms. In the previous slide, you saw there was like a $1,500 limit on, $2,500. That was the limit on firearms in that policy, but that wasn't listed in the first summary pages. That was listed on page 39 of 74. So you definitely want to look for that in your policy. That, again, review the entire policy. I see a question. It says, I had no idea you could hire an attorney to assist with this. Thought we were at the mercy of the insurance company who does not have our best interest in mind. It's very unfortunate, and I'll tell a quick story. I used to work for the largest insurance defense firm in the state of Florida. I represented the largest carriers for the state, and I went to a property. We did an inspection, and mind you, I'm defending the insurance company. We go to a property. I see a huge hole in the ceiling. I can see the sun and the clouds through the living room. And I call the client. I say, yes, this is a settlement case. We are not defending this case. We have an 80-year-old insured. She has a breathing mask, oxygen tank with her. And this is not a trial candidate. And my client says, file this motion. It's going to take 3 months to get heard because the judges are backed up. I said, I can't do that. That's unethical. And this, there's actual physical damage. She needs help. And my client wanted me to do the motion, delay. Delay is the best form of denial. So at that point, I no longer could work for insurance companies. And now that's why I represent homeowners and commercial property owners. Do I have a particular insurance I would recommend? Absolutely. So USAA, if you can get USAA, and I'm not paid by USAA, but if you can get USAA, they pay their claims. They love their clients. They love their insured. They are very expensive, but worth it because I rarely, I probably had to sue once, and just State Farm's the worst. As far as, these are my personal, for homeowners, not the best. USAA, I would say FedNat Insurance is my second. I don't really have a third because I can tell you the worst ones though. State Farm, Universal Property and Casualty. I guess Security First is so-so, Tower Hill so-so, they drag out the process, but who drags it out the longest? State Farm and Universal. 99% of these cases settle out of court outside of a trial. It's only when it becomes, do I have to pay the insured more than I would have to pay if I litigated, that it becomes a trial candidate, right? Like, so sinkholes usually go to trial because those are, the entire house is sunk. And there's a valid dispute that needs to go before a jury. But usually these homeowners insurance claims settle. Say they settle pre-suit. They can settle pre-suit with mediation, with arbitration, but rarely do these types of cases go to trial. And then
Nadia, and I'm not sure if you saw the one about separate insurance for firearms, or would it be under personal property?
Yep, we got to that one. It's going to be under the special limits of liability. It's covered under personal property, yes, but it's going to be a special limit of liability, which is within the entire policy, and that's why either you want to do Control F and search for the word firearms. If firearms are important to you, you have firearms, they are of value. You want to know what that limit is, because if someone came and you no longer have access to your firearms, or your firearms are damaged, you want to know what you covered under. So that's a great question. All right, I don't see any other questions in the chat.
All right. So before, and again, thank you so much, Nadia. Again, for that digital app, I believe Nadia suggested that if you put your email address in the chat, we will get back to you. I did capture about 10, but don't forget to add that in the chat if you're interested. And we are going to do two things. I'm going to introduce our next presenter. And while we're doing that, while I'm doing that introduction, we are also going to launch a poll just to get a good feeling of our audience. How many of you are current homeowners, or looking to be homeowners soon, or just gathering this information in preparation? So if you could respond to that chat, that should be coming up shortly. All right, so while we're waiting for that, I do want to take this moment to thank our next presenter, Jeanette Mora. Again, Jeanette had some personal challenges that involved her having to fly out at the last minute, but she still honored her commitment to speak with us this morning. So I want to personally say thank you. And Jeanette is an estate planning, probate, and guardianship attorney. She's a member of Wealth Council, a member of the Central Florida Estate Planning Council, and a past certified financial planner and wealth management advisor. She's also a member of the Florida Bar, elder law, real property, probate and trust, guardianship committees, a member of the Orange County Bar Association, the Osceola Bar Association, Paul C. Perkins Bar Association, the Central Florida Women's Lawyers Association, and the Hispanic Bar Association of Central Florida. So again, Jeanette is extremely qualified to speak with us this morning, and we thank her for volunteering her time this morning. So if you could respond to that chat, and then we will go ahead and bring up Jeanette's slides and turn it over to her at this time. Thank you.
Thank you, Ms. Irma. Thank you very much for that wonderful introduction. And I guess, well, can everyone hear me okay? All right, perfect. Nadia, hands down, thank you so much for that incredible, valuable information. Even I myself, I'm not a property attorney. I do come across, and I generally, refer my clients to people like Nadia. And this is a gem of information because Nadia represented the insurance company. So when you come across someone to help you out who understands the side that you need to, that where you need the advocacy, they understand, someone like Nadia would understand exactly how that insurance company is going to behave, going to respond, and what the things they're going to look for. So you have phenomenal representation with Nadia and her team when it comes to homeowner issues and protecting property after damages or loss. While my slides are coming up, thank you so much, Ms. Irma, for that wonderful introduction. I've been in this very amazing industry for quite some time now. I am a second career attorney after spending well over 15 years in the financial services industry. And similar to Nadia, I worked for some of the largest banks in the country and brokerage houses in the country. And right around the time during the 2008 debacle of financial services, if anyone recalls, some of you might be a little young for it, but when the stock market just crashed and issues were happening with credit and people couldn't get loans, and we were dealing with predatory lending when it comes to mortgage companies after that time, I myself found myself in a situation where my large financial firm had some rosy scenario pointers on how to deal with our clients. And to me, it did not sit well. I felt it wasn't ethical. And I, decided to start that kind of change over into what really I admired, which was advocacy for my clients. And that's what ended up having me transition over to putting myself through the, I don't know, Nadia, would we call it torture fun? 4 years of law school for me. I went part-time while I still worked full-time in my 40s. So that's that's definitely a bit of a superwoman move there. But oh boy, what a journey it was. And I'm so glad that I did it. I've been practicing now on the other side of the law and the financial things that I was exposed to in the estate planning environment. And so I handle more specifically, so Nadia handles, obviously protecting your property against loss and making claims against physical loss or other types of losses that may be intangible as well, and financial losses. So my role is to help people plan for how to protect the assets, to transfer your assets to your intended loved ones, to your beneficiaries, to your heirs, and not let someone else make that decision for you. Time and time again, we are facing issues where unexpected loss of life or unexpected loss of capacity has very, very interesting consequences that the majority of individuals just simply don't plan for. We think we're going to live forever. We think we're going to be okay forever, but something at a change. And then what happens to that property? What happens to your stuff? Next slide. we can get started there. I think this was self-explanatory. Thank you so much, Ms. Irma, for that great introduction. This is just a little recap of all of the things that I'm involved in. I don't know where I find the time, but somehow it's in there. Glad to be part of the Central Florida organizations and be able to connect with my fellow members of the bar. Next slide, please. So what we're going to talk about in the next 30 minutes or so is, really what is estate planning and how does it protect your property? So we're talking about protecting that property to leave a legacy, effective and efficient estate planning, navigating through what does an estate plan look like? I know that many folks hear the word estate planning, but what does that really mean? I didn't know what it meant prior to my exposure within my industries, because to me, it was just something rich people did, like in Dynasty or soap operas. Oh, what's a trust? What's this? And we're going to talk a little bit about some of those tools. What are some of the most important documents that you should have? Nadia talked about what are some of the most important reviews that you need to do in your policy. Well, there are some documents that you need to have in place in order to protect your legacy and protect your property to pass on to your loved ones. What is probate? How do you avoid it? What is probate? Some of us have had some experiences with loss of loved ones and maybe have dealt with adverse scenarios in courts. We'll talk a little bit about that. The risks of not having a plan if you don't have any documents in place, other considerations. And so we're gonna have a little bit of fun, certainly open in the chat for some questions. Everyone's cases, sometimes the cases are very individual, so I'm going to talk more on a general side, but hopefully we'll be able to touch bases on some things that's important to everyone. Next slide, please. All right, so estate planning, that big word. What does that really mean? Well, that means planning for the unexpected. Effective transfers. What are the transfers that accomplishes your objectives? Essentially, we want to be in control of giving and leaving what we have to whom we want it when we want it. Is that right? So how do we manage that? And that's one of the things that estate planning covers. It manages the risk of incapacity. If you become incapacitated, who manages your property? You're still alive, but who manages? Who has the authority to do that? Who has the authority to make healthcare decisions for you? Do we have documents in place for that? That's part of estate planning. How do we provide for our loved ones in case we can no longer work, in case we're incapacitated, provide liquidity needs at your death? That's part of estate planning. Charitable intention. Some of us have nonprofit or charity intents. That's also part of estate planning. So as you can see with all of these things, estate planning is a very practical tool on our day-to-day lives, promoting family harmony if you're married, if there's second marriages, blended families, planning for children with special needs or incapacity all the way throughout their adulthood. That's part of estate planning and part of what estate planning means. So estate planning covers a whole lot of a wealth of different information that we are going to touch bases on as we continue. Next slide, please. So estate planning also has the opportunity to be able to transfer and the efficient transfers and minimizing transfer costs. So if it is part of someone's composition, estate planning can also help with how to save money after someone becomes incapacitated or passes away. And we'll talk about that too, because it can be very expensive when you don't have a plan, when you don't have that life coverage. It can become very expensive to be able to ultimately transfer things and transfer properties to your loved ones. Next slide, please.
And Jeanette, one quick question. So I know for me personally, and somebody sent me this question as a text, a lot of this seemed like something we should do once we hit our 60s or 70s. So, something that older folks should do. So, can you speak to that? When ideally is the best time for you to begin this kind of documentation?
That's a great question. Thank you so much, Ms. Irma. It is, believe it or not, at every stage of our adulthood. So even when you turn 18, years old. There are certain documents that even an 18-year-old who now has capacity to sign should have in place in order to protect for certain events. And that's, for example, the event of incapacity, or the event of not being able to direct who makes healthcare decisions for them, or having, so we think we live forever. That's something I'm going to do later on in life. Not necessarily. Even for some of us who have children who are turning the age of 18, I just had this with my sister. My nephew turned 18 in December, and he has a medical condition. He has Crohn's disease. My sister is very involved in his medical care. And so she said to me, Jeanette, I need to make sure my doctors won't talk to me. I need to make sure that I can access his medical records. So we had to draft a couple of documents we're going to touch bases on for her to be able to have that authority, because as soon as you hit the age of majority at the age of 18, you are, and in the state of Florida, I believe it's 18 pretty much in all 50 states, but you are now at the age of majority. You are considered adulting. And so for us parents, for you parents who have children that are about to turn 18 or are young adults, that is as early as you can start planning for the unexpected and planning for certain legal authorities. And then of course, as soon as you start gathering assets, if you buy a home, if you have a car in your name, things that are start being titled in your name, if you have a bank account, again, even at the age of 18, what happens if you pass away to that bank account? And so sometimes, and even at that young an age, it can be more simple planning. But yes, thank you for that question. It's not in your 60s. It's as soon as you really can sign a document, and that usually is right at the age of majority. Thank you for that question. And so as a segue into what I just talked about, so what's an estate plan look like? What does that mean exactly? An estate plan is putting together documents that are important to set aside and to put instructions on what happens if you die, like a last will and testament. We'll touch bases on a little bit of these as we move on. Last will and testament, a testamentary trust. What does a trust mean? We're going to touch base on that. A will or pour over will, what does that mean? And this presentation I can run for hours. So we only have a half an hour to talk. So I'm just going to really throw in some nuggets. And then, certainly I will recommend for everyone to have consultations or talk a little bit more in depth depending on your scenario. Things like a trust, power of attorney, right? Advanced healthcare directive. So these are documents, this is what a modern estate plan looks like in terms of the basics of depending on everyone's financial family circumstances. Next slide, please. So let's start with some of the initial things. I know many of you have heard of, okay, well, what's a will? What's a trust? What's the difference, right? Generally, when you pass away, if you want to have something in place where you direct how your things, your property, not because of damage, but because of you no longer being alive, is being transferred to your loved ones. If you have children, if you have a spouse, if you don't have children and no spouse, possibly to other members, other people. Okay, what's the difference? So a will is generally a document that expresses when you pass away what your wishes are. If you have children, a will can name a guardian for your minor children. It can leave gifts for the people that you are intending to. I have someone who left gifts for all of his nieces and nephews. He wanted to make sure his nieces and nephews were, had some form of coverage of something that they wanted to leave behind. They specified that in their will. It becomes active after you die. So a will is something that you put aside, and when you pass away, someone pulls it up, we present it and say, okay, this is what this individual, how they wanted their assets to pass and how they wanted their property to be held after their passing. It must go through probate. I'm sure some of you might have had some experience with some loved ones or parents or grandparents and observed that particular activity. Probate is a court process. A will has to be legalized and accepted in probate before your assets are transferred to your loved ones. That can be very expensive. I've seen some probates go upwards into more than $20,000 sometimes, depending on the complexity of the assets, the complexity of the beneficiaries. And it can be very lengthy. In the state of Florida, we are required to close a probate. It can take about a year. However, I have some probates right now that we are going on year 2.5, and we still haven't settled the estate. leaving beneficiaries in a waiting game in terms of ultimately when those assets can be transferred. Many of you have heard of something called a trust. A trust is an alternative, or trust is a supplement to a will. What a trust does, and this is my best analogy on a trust, where a will is activated when you pass away, and a will says, this is how I'm going to determine, this is how I'm going to distribute my assets. What a trust does is gives you, the individual, literally power to control for as many years as you want, even after you are no longer here on this great earth. You can actually say in a trust, you're going to name someone to manage the trust, right? That's a fiduciary relationship. You're going to give the power to someone to handle your assets for the benefit of beneficiaries. That's because you don't want to give some of your loved ones maybe something completely outright at the age of possibly 18 years old. You ready to give your life savings to your 18 or 19-year-old kid, right? Possibly not. So you can actually designate how long that person's going to manage, that person you're going to choose to manage those assets for those beneficiaries. There are things like a revocable living trust where you can actually talk about how you're going to distribute your assets throughout over time, and you can also revoke that. There's a testamentary will. Let's assume you have someone you have a minor child, and basically all you have is going to go to that minor child. Some individuals may do a trust within a will, and you're saying, well, I have a minor child, so I'm going to name this trust so that you can manage all these assets for my minor child. And when my minor child turns a certain age, 18, 25, 30, 35, whatever the case may be, that's when we're going to distribute the assets. But I want to make sure I protect that child and protect the property for that child. Next slide, please.
So Jeanette, you have a question in the chat.
Great.
What documents do we need to protect property for longevity? For instance, we have minor children, we want homes to go to them, but we don't want their spouses to get it, or for taxes to go unpaid and then foreclosure happens.
This is a great question. Thank you. And that's when you are making constructing a plan with a trust, right? So a trust, if you have minor children, is one of the best tools to have because it manages, first of all, a child cannot inherit assets, right? A minor cannot inherit assets. And so when you're drafting a document, when I draft documents for clients with minor children, we incorporate the use of a trust so that those assets can be protected on behalf of that minor child for as long as, and this happens for as long as that child lives, or as long as you direct it within that document. It's a contract. It's a contract within yourself and someone else who's a fiduciary to manage that property on behalf of children of a second marriage, for example, or a minor child, or a special needs child who cannot inherit property. And so there are different tools, but those are the types of tools when we're dealing with trusts and protecting property. So we deal with insurance policies to protect property against loss. We're dealing with a trust. Trust is an excellent tool to protect property to be managed beyond someone's death or even incapacity. This is a slide here that kind of just delineates a little bit and goes to the answer that also to the answer to the questions. It's very timely on the difference. So wills versus trust. In a trust, does it name a guardian for minor children? A will can name a guardian for minor children. A trust has a fiduciary responsibility already, so you don't need to name a guardian because the trustee is actually that fiduciary. Can it be challenged in court? Usually not, unless there's some form of fraud or duress or something that someone wants to allege. But usually trusts can be more protected, whereas a will can. A trust does not go through probate. Here's another form of protection. What we file with the court, remember how we talked earlier where a probate can last over a year, sometimes 2 or more years. A trust, generally, the trustee is a fiduciary that can already immediately start managing those assets and not wait for the court to enter orders, whereas a will do so. And so on and so forth. There are a lot of different rules and similarities, but one of the main things is that a trust becomes active on signature, whereas a will becomes active after you die. A trust is a current contract with a fiduciary, a trustee, a person that you are appointing to manage your assets. That could be yourself, while you're living. That's why it's called a living trust. Then when you die, the trust has a successor trustee, a person that you are going to name as a fiduciary to continue on the management of your assets. Next slide, please.
And Jeanette, can you, and definitely feel free if this is going to be covered someplace else in the presentation, but there was a comment in the chat about how this person's employer group has a legal plan and all of the estate plan documents were covered at 100%. And I've also received a separate question, should we be concerned about accessing these documents on our own online? In our digital age, you can go out and find all sorts of legal documents online, but what are your thoughts? Are we putting ourselves at any risk when we take that approach?
Great question. The first question, in terms of having the legal benefit program that many employers would have, my answer to that is yes. Take advantage of that, because those are attorneys that have entered their name in as part of those organizations. So these are attorneys that are qualified. They are doing it for usually sometimes a lower fee than they would if they were to take you on as a client individually, because they've become a part of that group. Like Legal Shield, I think, is one of them. And I would say take advantage of that if your employer does offer it, because it's going to be done by an attorney. It'll be drafted and reviewed by an attorney, and the signing and the entire engagement will be done by an attorney generally. And so you should have the opportunity also to have a consultation, to have a questionnaire, to get your detailed information that is unique to yourself and your circumstances, and they will honor that at a fee that will probably be even more beneficial to you than if you were to go directly to an attorney, an estate planning attorney. On the second prong of that, the do-it-yourself plans, I would highly recommend against those. Generally, estate planning is very state specific. I'm assuming everyone here is in Florida because of the connection with Nadia, but if not, but they're very state specific. I have seen some big mistakes in the do-it-yourself plans, and they may not follow the statute, they may not follow the rules, they may not be admitted. I've seen durable powers of attorney online, and ultimately, it ended up being invalid for some reason. And so the do-it-yourself plans, you want to be very, very careful with, but they can become more costly than the possible $99 that you might have paid for it online, that they may offer it on online services. I would highly recommend against those, especially if you've got unique situation with properties, children, minors, and things of that nature. So that would be my 2 cents on that, is just stay away from the do-it-yourself plans, because they can really, really not capture your intent if you're not familiar with the requirements by state law. Thank you. Thank you. This slide right here, very quickly, is another, it's just another distinction between happens in terms of estate planning. And we talked earlier as to how soon can we start one. Well, estate planning involves planning for incapacity and planning for death. And these are different documents that make sense on each side. So if you're planning to plan for incapacity, it's important to have these 3 types of documents, the most basic of them all. And they are a financial power of attorney to allow someone that if you are incapacitated, to access your bank account, talk to your credit card and people, to talk to your insurance companies, to, if you have a claim against your property and you are hurt and you are incapacitated, guess what? People like Nadia, attorneys like Nadia, are going to need to know that someone has a power of attorney over you who is able to litigate or make claims on your behalf because of your injury, and you don't carry the capacity to do it, but you need someone to step into those shoes involving those types of claims. Advanced healthcare directive, that is someone that's giving someone medical authority over your providing consent for treatment, providing withdrawal or not having certain treatments, having access to your medical records with a HIPAA authorization. We saw this a lot particularly starting in 2020, due to the COVID crisis and the pandemic, where individuals found their loved ones in the hospital, unable to make their decisions, possibly in respirator situations, and family members were desperate because they did not have access to certain things of their loved ones. And having these 3 basic documents, which are not very costly, can save thousands of dollars. In the absence of those things, you would then have to get legal authority through what's called a guardianship. Go through a guardianship that can be thousands of dollars in order for someone to have that absolute legal authority to handle your financial matters as well as your medical matters. So these 3 basic documents, if you can get those at the minimum, we are at higher probability of becoming incapacitated than we are of dying. And so those 3 basic documents can help a lot in giving you some peace of mind that someone else is your backup in case you're unable to make those decisions. To plan for death, there are other documents that make sense. It's a will or a trust. You have burial instructions in those documents. You can name a guardian if you have minor children on the second parent to die if there's no surviving parent. You can direct for children of special needs if you have a child possibly with autism or cerebral palsy or any other. I come across a lot of these cases where there are children of special needs and you want to be able to provide for them. That's how you can plan for your death. Direct special gifts of assets as well. So if you've got certain specific things, like if you have a gun collection that you want your specific uncle or nephew or someone specific to have that, then planning for death to be able to transfer that on. Next slide, please. This slide here talks a little bit about other aspects of the proceedings. Probate. Probate is a court proceeding, as I mentioned earlier, and it concludes all of the legal and financial matters of the deceased. However, it also involves possible costs that deal with possible taxes, estate taxes, income taxes, and it all depends on your individual circumstances. We're certainly not going to get into talking about taxes and death taxes here. In the state of Florida, there really is no death tax, which is a good thing, which is why a lot of people come here to bring their properties here. So this is a favorable state to save on death taxes and estate taxes in the state. But it also involves a lot of different other factors in terms of protection. Asset protection for your children from spouses and creditors. There are certain documents as well that can also help protect from children and their spouses. So you may direct, for example, if you have a child and you want to say, listen, this is what I worked hard for, right? I don't want to give this, if I pass away and my child ends up with the things that I worked hard for, well, what if that child gets divorced? What if that child passes away after they are married, and now that spouse, whom I have nothing to do, I may be okay with them, but that spouse who I have nothing to do is going to end up with the stuff I worked for, right? That is really not a feasible thing. And so there are instruments within a trust document that you can design to protect assets from spouses, to protect assets from people's creditors, to protect assets from a child or a loved one who may be a spendthrift person. Again, you might have been in the company for a very long time. You've accumulated quite a bit of assets in your 401k plan or any other state. You say, okay, wait a minute, my kid is 22 years old. I'm not letting my kid get all this money. I'm going to make sure that it's protected from his creditors, his or her creditors, and his or her, second creditors. So asset protection is a big thing when it comes to, also drafting these documents. Next slide, please.
And I'm sorry, Jeanette, you have there's a hand raised. I think we have a question.
Okay. Mm-hmm.
Was there a question? If so, you can unmute yourself. Okay. Oh, okay. I'm sorry. They clarified no question. I'm sorry. Continue.
No problem. Okay, cool. So facts about probate. I'm going to move a little on the quicker side here, but so probate is public. So probate is something that is accessible through the courts. Probate is complex, like I mentioned earlier, and it always in Florida requires hiring an attorney. Some people can do it themselves in other states. Highly highly not recommended. Probate can take time, as I mentioned earlier, and probate can be very expensive. And so that's the process of, after you pass away, how do you administer those assets? Next slide, please. Making a living trust. And again, this is very high level and it will spawn a lot of more questions. And I've touched base a little bit on this. Grantor, you grant assets to a trust. All right. So when we do a living trust, you're going to say, hey, I am the family trust of Ms. Robinson Family Trust, right? So I'm granting all of my assets to the Robinson Family Trust. I'm going to be the first manager of that trust because I'm going to manage these assets as I want because I'm still living, okay? Guess what? When I die, these assets in my trust are going to avoid probate. That is one of the biggest benefits. One of the biggest benefits. It's not going to be tied up in a lengthy court. The person that I'm going to appoint as my trustee is going to simply manage it according to my contract with myself, the contract that I set in place to manage my assets. Assets are immediately transferred to your trustee, which initially is you, or after you die, someone that you've named in the document. And it's going to provide for the care of all of my beneficiaries that I name in that document, whomever they may be. Does not have to be your spouse or minor children. It can be other individuals as well, as we named earlier. We're going to take care of people's health, education, maintenance, and support. Again, we're there to benefit our loved ones that we're going to name on there. You control the distribution property to beneficiaries over their lifetime. I had a trust. I had someone who came to me with a trust that was a lifetime trust. So this mom, who was sizable assets, had a trust for her only son, right? Her only son was to get certain dollar amounts or certain percentage of what she left him throughout his life at certain age intervals, starting at the age of 25, then at the age of 30, 35, 40. And guess when the final distribution of that trust was? When the guy was 65 years old. She literally controlled her money far beyond her passing until her only child was 65 years old. Is that a benefit? Maybe, maybe not. It depends, and that's why you got to talk about what your desire is. I mean, I'm sure she had her reasons for doing that and for making that decision. And promotes investment continuity. You have someone that's continuously managing it to invest that money over the life of that trust. Next slide, please.
We have a quick question. How or who is going to be responsible for dealing with probate? Like who owns that responsibility?
Excellent question. So in your will, you name a personal representative. In the state of Florida, it's called personal representative. Other folks have heard it as the executor in other states. And so that's the more common term. So that person is a fiduciary that is in charge of doing all the legwork, right? In terms of dealing with a probate, they're the ones that file the petition with the court. They're the ones that want to have that authority from the court in order to handle the estate, in order to handle all of your assets afterwards. They're the ones that, once they have also the authority, can make phone calls, talk to people, usually go to a bank. A bank will say, are you the executor? Are you the personal representative? And if you're not, then they're not going to talk to you. Right. So that's the titling of that. And that usually that person is named in the will. Just in case there are assets that are not under a trust, then you do have to have a probate, which is the majority of the time. Then a personal representative is someone whom you've designated in your will to handle things for you. Good question. We're going to stick to this slide here. Risks of no plan. All right, what happens if I don't have a will? What happens if I don't have a trust? What happens if I don't have anything and I pass away? Okay, so each state has what's called intestacy laws under their probate code, under their probate rules. And so intestacy means that you've died without any documentation. You've died without a will. That means that each state is going to direct how your assets are going to be distributed. So even if you don't make that decision, the state's going to make the decision for you. And for example, in Florida, so the intestacy rule, right? That means that you've died without a will. When you died with a will, it's called testate. When you die without a will, it's called intestate. And so under the intestate rules, it means, let's assume if you're married, right? If you're married and you have children of the same marriage, If you're married and you have children of the marriage union, then 100% of anything that is in your name only, 100% of your estate goes to your spouse, right? If you're married and you have children from a first marriage, plus you have children of the existing marriage, I'm just throwing something, this could be a whole other class, right? Whole other webinar. If you're married, for example, the state says that 50% of what you have goes to the child of your first marriage, and the other 50% goes to your existing spouse, but not the kids of the existing marriage, if that makes sense, right? If you're not married and you don't have children, the intestacy rules say that all of your assets go to your parents if they're alive, right? So there are rules, and it's almost like if you've seen those ancestry.com, kind of family trees out there. So how does that pass down? The state's going to make the decision for you. Here's where the problem lies. That's not whom you may desire to get your assets. And we saw this a lot in issues where young individuals will pass away. Perhaps they had a loved one, a girlfriend, boyfriend, same-sex partner. There is nothing in the intestacy rules that will allow for them to have any interest in your estate. Even if they might have been living with you for the past 5 years, you shared everything together, you had, you lived your life together, guess what? The intestacy rules does not recognize that. It's not fair, but it is the law, and the law is going to be very black and white when it comes to the intestacy rules. I've had to explain that to many, many of my clients who have loved ones, caretakers, whomever, and it's unfortunate, but you've got to have those documents in place, especially if you're a single person and you want to direct who stays with your things. Otherwise, the state is going to make that decision for you. Next slide, please. Oh, and let me add one more thing too, as well, into this intestacy. If you are alive, if you don't pass, and something happens, and I had a case where it was a partnership, a domestic partnership. They were not married, but they were together for about 20 years. A very loving relationship, so on and so forth. The one partner had an aneurysm, sudden, right around Thanksgiving. This is still a case that's active, and the partner who's around was not able to access anything of her partner in order to help. No bank accounts, nothing. The family of the partner that had the aneurysm came on board and said, no, we're going to take over from now, even though she hadn't had a relationship with the family, even though she hadn't had a relationship with any of them, or it was a very sad case. And unfortunately, the rules are there that if they're in the absence of any documents giving somebody access and authority to your things, even when you become incapacitated, the next of kin has that immediate, preference, if you will, in order to do that. So you want to plan for it on both ends. If you become incapacitated, if you're single, you want to make sure that the people that you direct are the ones that have the authority. This slide here, risks of a will-based plan. And again, I've already touched base on this earlier, in the sense that a will only takes effect at death. It does not plan for incapacity. The will has to be probated. I've touched bases on that, and that, even if they create a testamentary trust, so if you have a minor child and you say, okay, I'm going to do a will, and in that will, I'm going to direct a trust for my minor child, that will still has to go through probate, as opposed to doing a trust separately than with a will. And again, these can get a little bit complex, but it's something to understand the distinction on. Next slide, please. So a will may also be appropriate. However, we talk a lot about trust and when it's appropriate, but that doesn't mean that everyone needs a trust. The trust can be complex and can be a lot lengthier. A will may be appropriate when you're dealing with a small estate. It's informal, when you're not dealing with minor children, perhaps, or you're just kind of leaving everything you want outright to someone. Then a will may make sense in terms of how to make sure that what you want stays with the individuals that you have. So we don't want to, we're not talking against wills. I think it's important to have a will no matter what. And so even when perhaps there's an anticipation of litigation, for example. If there are beneficiaries who are just, possibly you have siblings that may be fighting over things, a will can actually be very clear on what your intent is, and a judge can oversee that and make that decision in terms of what's the best approach in actually getting families to come together on behalf of your assets. Next slide, please. Okay, joint tenants with rights of survivorship. This is a big one that I'll touch bases on, only because it's very common to say, I've heard some older parents and even grandparents say, well, I've added my son to my account. I've added my child to my home in title. This has to do with titling of assets. And so when we title things, now probate and all of that is when you have something that's in your name only. When there's something that is joint tenancy, and we have a lot of that when we're dealing with our spouses. Most of us, we may have our checking accounts, bank accounts with our spouses in joint name. But one of the risks of adding a joint person to an account, especially when you're dealing it with children or boyfriends and girlfriends, oh my God, do not ever add a non-spouse to an account of yours or take a loan out together as joint tenancies unless you're married. But what that does is there are risks. What happens if you both die at the same time, simultaneous death, right? It also can cause what happens if there's a tenancy in common. That means that you've given 50% of your asset. By adding someone into a joint tenancy, you're giving 50% of your assets to someone else. And that gets into a little bit of complications. If you died, that joint tenancy with rights of survivorship can actually automatically transfer all of your things to that other person. Okay, again, that's a risk. Sometimes we do it for convenience purposes. However, in many cases advise against it only because it can cause issues. If that person gets sued, that joint tenancy account or that joint tenancy property becomes a part of their assets that can be subject to a judgment. And that's not likely what you wanted if you are adding someone as a joint tenancy on anything that you have titled, like a bank account or home property, home ownership. Okay. And there are other issues there that can go on. And again, there's a lot to unpack here, but this is a very big thing to do. One of the things I recommend as an alternative to a joint tenancy with rights of survivorship or joint tenancy titling, if you all have bank accounts and you have people that you say, you know what, if something happens to me, this person can stay with my assets, this person can go. I recommend adding what's called a pay on death beneficiary on that account, as long as they're an adult. And you have an adult child and you're okay with outright gifting that upon your death to that adult child or adult other beneficiary if you don't have children, then you can add a pay on death beneficiary by simply going to your bank and adding that person to your account. This is a mechanism that avoids probate. There's no court intervention. You don't need a will for it. You're just simply adding someone as a beneficiary to that account. Life insurance is something else that you also can avoid probate by adding a beneficiary. So anything that's beneficiary based avoids the entire court probate proceeding overall by adding people as beneficiaries to your assets. Next slide, please.
Jeanette, quick question.
Yep.
If the bank accounts already have a beneficiary and the property is in a Lady Bird deed, do you still need a will?
Okay, great question here to unpack. So we've got three different things going on there. So if a bank account has a beneficiary, the beneficiary transfers by operation of law. Operation of law means that when you have a named beneficiary, so a will has to do with something that has to go through court so that the court determines who the beneficiaries are according to the will. Guess what? An operation of law beneficiary, when you named a beneficiary, that actually supersedes whom you name in a will on something that is named beneficiary. So those are going to be competing interests. The will is not going, that will designation of who, so you've got John as the pay on death beneficiary in your bank account, but in your will, you're saying, actually, I want my bank account to go to Jane. Well, guess what? Jane does not take. John takes because he was named beneficiary in the bank account. Okay. Hopefully that makes that clarifies that. A ladybird deed is a different type of instrument. A ladybird deed has to do with your real property. That's now we're talking back to home ownership. So you have home ownership. I, Jeanette Mora, I'm the grantor, and I am giving my house to Jeanette Mora for my life, right? I am a life tenant now, for my life. And at the end of my death, or if I was married at the end of the second to die, if it was me and my husband, then that deed, this property will now transfer to my contingent or remainder beneficiary, which is Nadia, right? So now this is something that is recorded in public records, and that is an automatic transfer of property ownership on real property. So those three things have three different meanings, but a ladybird deed has to do with real property, and it involves recording a deed, giving your property to yourself for life and leaving contingent beneficiaries that you named in the deed so that it continuously runs in title. This is another probate avoidance type of tool because it doesn't go through court. You've already named the beneficiary of your house. You've already named the beneficiary of that property. Where a ladybird deed does not work is if you have minor children, because you don't want to put the name of a minor child on a deed, right? And so that's when we can look back and say, okay, I'm going to name my trust, right? Possibly as a remainder, and that trust is going to manage it on behalf of my minor child until my child becomes a certain age. Again, a lot to unpack here, and I know we can go on forever and ever. There's a lot of questions that I'm sure can come through, but it does make sense, to really understand the unique circumstances, to really communicate your unique circumstances to someone, and getting us to our slide here. But I do see a couple questions here. Let me see if I can address. Let's see, we have one. My husband and I have some separate bank accounts. Each of us knows the passwords to get the accounts and can transfer the money to joint accounts if something happens to one of us. Should we do that or go ahead and add each other as a pay on death beneficiary? Great question on our separate accounts. This is what happens on a separate account. So after you pass away, if you pass and you have a separate account in only your name, you may have access, or your person who has access to it, in title, you're now deceased, right? And so really access to that account is not, we don't want to know about it. It's not legal because the person has passed away. So therefore, access to that account is not considered the right thing to do. And what also happens is that ultimately, when Social Security, when the vital statistics ultimately reports the death of someone, there's now an electronic, almost automatic electronic communication that gets really spit out to all of those financial institutions, where then ultimately that Social Security gets reported to be deceased. And then the financial institutions have an internal mechanism to avoid things like someone else unauthorized accessing the account, to freeze that account almost instantly. I want to say that there's about maybe 24, 48, 36 hours, or more hours, a few hours or a few days of access, but we highly recommend against that. So to answer that question, if that the intent is for the other spouse to have immediate access to the account, yes, I would add each other as a pay on death beneficiary. I had my parents do it. My mom decided to have her own account. I said, Mom, you need to make sure I am not going to court for this, right? So I made sure she had my dad and myself on there to make sure that we don't have to have the risk of things getting frozen. And a pay on death is a very simple claim. It's really going into the bank with a death certificate, the person that's designated, and saying, I have a pay on death on there, and you're named, and you simply go in and claim that. Again, no court intervention involved in that respect. So very, very good question. So hopefully I would recommend against that. Other question, what account, bank, life insurance, investments accounts should you name your trust as beneficiaries? Okay. All right, I'm going to a Nadia answer here. It depends. It is going to depend on the circumstances and who your beneficiaries are. If your beneficiary is your adult son or daughter who's in her 40s and she's got her kids and responsible and it's pretty standard, then you can easily name an individual as a beneficiary, right? If your beneficiary is a minor child, If your beneficiary is your child of your first marriage, and you want to make sure that the children of your spouse that are not of your marriage, so other stepchildren, you want to protect your decedents and your heirs from possibly going things to the husband and then going to those kids, then you can name a trust. When you have a special needs child, I had a case where there's one child, and that child was an autistic child, and there's a special needs trust created for that child. And so they named the trust as the beneficiary of the bank account or life insurance for the continuity of the management of that child. And so there are many circumstances there where you would name the trust as a beneficiary. But then again, it depends on your individual circumstances. Okay, perfect. I think we're wrapping up here. Like I said, we can go on and on and on because this topic is just so comprehensive, and everyone's things individual. So what happens then? We recommend you have an estate planning engagement. What does that mean? You got to work with an attorney. You have to the attorney's going to try to understand what your individual circumstances are, what your individual scenario is. In many cases, an attorney will have a questionnaire. Give me your family information. What is your intent? Do you have a charitable intent? Do you have minor children? Do you have children that you have issues with? Hey, do you have a child that you want nothing to do with? I hate to say it like that, but that's true. I have had someone in a will tell me, I specifically do not provide for John Smith, and he knows why. Period. End of story. That's it. Right? As long as that's an adult person, you can't really disinherit a minor child, right? Because you have a duty to protect that minor child. But when it's an adult, you do have the opportunity to say, I specifically do not provide for this person because they know why. It's all about your personal intent. There's a big, it depends. You get with an attorney. Certainly, I am available. We have, we've got a wonderful, team that we're drafting a lot of documents for. And my love of this field is that when we're done, it takes a little time because we've got a lot of stuff to draft. But when we're done and we sit down with you and we get your documents signed, it's that peace of mind that I see with my clients that really gives me that joy of that we did something right, and they put down, they give them the peace of mind that they actually laid down their intent. So don't procrastinate on this. It's a big thing to procrastinate on. We're going to do it later. If you have children, whatever your circumstances are, definitely get with an estate planning attorney. If you have the opportunity to do it through your employer, I would say take full advantage of it and say, I want to draft some documents, take full advantage of it. Thank you so much for your time. Thank you, Nadia, for inviting me to speak here in this great organization. Alpha Kappa Alpha Sisters, love you all. And here's my information, my contact information. Happy to share some more or schedule consults and, to help you out. So thank you.
Jeanette, thank you. Nadia, thank you. Both of you were just incredible this morning. And thank you, our participants, for engaging, for bringing up, different things. I think we all learned something this morning. So, we don't want to belabor the time, but just appreciative for every single one of you. We will be sharing this recording on the Delta Omicron Omega chapter YouTube channel. So if you have not subscribed to that, please, go look for us and subscribe to the channel. And we'll have some more content coming in the future. Again, thank you to our amazing presenters, and I hope everyone has an amazing day. Madam Basilisk or Dr. Boyd, would you like to say anything before we close?
Thanks again. This has been awesome. We are so grateful for our presenters, and thank you all so much for joining us. We hope you have your takeaway and are planning to protect your legacy. Thank you again. Thanks so much.